Good evening. Good evening, everyone. All right. Okay, guys, I'm really excited today because I got a new iPad that I'm going to be using on my live. So that way I can better read your questions because when I use my phone, the print is too tiny. So let me know how this works for you guys. Hopefully we have a really great session today because I have a great topic. So, for those who do not know me, let me introduce myself. My name is Odunlami. I'm an immigration attorney at the Odunlami law firm here in Cedar Knolls, New Jersey. And my law firm serves clients from all 50 states because immigration is federal law. And so, regardless of where you are, if you need our assistance in family-based humanitarian removal, we're here to assist you. So, well, thank you for joining. Thank you, guys. Let me know where you're joining from. Oh, this feels so good to be able to read what I am seeing because typically I'm never able to read the print. Oh my God, I feel like I have a new lease. So, hi, Timmy. Thank you for joining. Good evening. So, I have a really great topic, and I didn't even really prepare this topic because it was just a lot of information that I've been seeing and I've been meaning to get back to you guys. So I just figured I'll just begin the live, just give you information and answer your questions. I know a lot of you have questions. So I want to be able to spend some time answering some of your questions. So the topic I want to talk about today is the mistakes that you make that can cause you your green card, that can cause your green card to be delayed. Hello, Zach. Thank you for joining from South Carolina. Thank you. I am Ify Sunshine. So nice of you to join in. So I want to talk about the mistakes that you can make that can cost you your green card. And I want to talk about the fact that this current administration is really doing too much, so much. And I want to reassure you guys that nothing they are doing is really that new, apart from this mass deportation and then going to social media to brag about it. And I'll give you an example. Um, I read up that the administration had said they were going to review people that already had green cards and possibly revoke their green cards. And I want to tell you that this has been happening in the past. When you have a green card, your immigration journey is not over. So now, saying this is meant to make green card holders now anxious, worried, and all of that. But the truth of the matter is, and I've been saying this to all you guys for a long time, just because you have a green card does not mean that your immigration journey is over, does not mean that you have a pathway to citizenship. It does not mean that your green card cannot be revoked. So nothing that they're saying about screening green card holders, again, that's not new. That has always been the case. They're saying, the administration is saying that if you have a green card and you've committed some crime, that they will take the green card from you. That is not new either. That's the law. It's always been there. So I want to tell people who are anxious because of the rhetorics of this administration to just keep your ears so that you know what's to the ground, so you know what's going on. But to a large extent, the only thing that's new is the bullying. The the lack of due process in certain um, processes that they are undertaking. But a lot of this, oh, we're going to do this, we're going to take green cards away from green card holders, we're going to denaturalize US citizens, we're going to do that. They don't have the capacity to do all that they're threatening to do. But how can you protect yourself so that you don't worry endlessly and needlessly? What you need to do is, first of all, make sure that you are following uh, uh, some of this guidelines I'm going to give you. So I want to talk about, because what I really want to talk about today are the common mistakes that can cause your green card to be delayed, common mistakes that can cause you to get your green card taken away from you, common mistakes that can cause you to lose your green card. That's what I want to talk about today. So I'm going to be a little all over the place because I didn't really prepared in an orderly manner because there was just so much information, and I just figured out I'll just speak from my heart. So I did a consultation the other day, and it was somebody who already had a green card, a 2-year green card. And let me go back and explain what a 2-year green card is for those who do not know. A 2-year green card is, which is also called a temporary green card, is what you get when you're married to a US citizen or green card holder, and your marriage is less than 2 years, right? And so if it's less than 2 years, you get a temporary or conditional green card. And what that means is that when 90 days before the termination of that temporary green card, you have to remove the conditions from the green card, which is you have to file again, you have to prove that it's a bona fide marriage, you have to, and if you can't prove, if you're still in marital union, you're together, you're supposed to do it jointly, right, with your spouse. However, in many instances, the relationship doesn't work out for one reason or the other. And in that case, you should hopefully have a waiver that allows you to go ahead on your own to get your green card. So this is where this error happened for this person. This mistake was, the first mistake was the person used the assistance of notario, right? Somebody who's not a lawyer, but I guess fills out immigration forms. And that's the difference between having a lawyer do your work and having somebody fill out the immigration forms. Immigration forms are not hard to fill out, name, address, where you live, your parents. But it's the mind, is the process, the thinking, the strategy, whether you should be doing this or should be doing something else, is where being an attorney comes into play. So what happened was he was married in a really bona fide marriage, I believe that, right? And everything was going on really well. They had he got his green card the first time, and then he needed to file to remove the conditions on the green card, and they removed the conditions jointly because they were still together. But at some point, the marriage soured. There was a lot of bad feelings, and instead of the person who helped him file the removal, instead of the person to go back and amend the joint filing, because that's what you're supposed to do when you file jointly to remove the conditions on your green card. And after that process, after filing to remove it with your spouse, you're no longer with your spouse, or you're separated, or there's a problem going, there's a problem with the relationship. If your spouse is still, you're on good terms, they can actually continue to, they can join you in the removal if you're on good terms. But if you're not on good terms, you want to see if there's a waiver that's available to you. So now there are 4 waivers available to people who have a 2-year green card, right? Based on marriage, of course. It's either you were abused in the relationship, there was abuse in the relationship. This is the VAWA kind of waiver. Or you are divorced, and you have a divorce decree, because if you don't have a divorce decree, that's not helpful. Or you can prove that that you would suffer there was extreme hardship during that conditional period that will prevent you from going back to your country, or just some kind of extreme hardship. Or maybe the spouse had died and was no longer available, right? So those are the 4 waivers that are available to people who have a conditional green card. So now what this notario did was basically not realizing that the best thing was to have a conversation with the petitioner and ask, well, what's going on with your relationship? Is there a way that we could utilize one of these waivers? Now, after talking to this person, I realized there was abuse in the relationship. They could have used the abuse waiver. They could have filed for a divorce to get the divorce waiver available to them at some point. But no, the notario told them, well, just talk to your spouse, beg her to go with you. And that never works out well, because when emotions are involved in the breakdown of relationships, you can never trust that other person to have your best interest. You guys know that, right? So, but this petitioner did not know that. So he follows the advice of the notario, and basically his spouse is like, well, yeah, I'll go. After he pleads with her for whatever, months, whatever, they go for the interview. And based on the way she's responding in the interview, they separate them. And so now this non-citizen does not have any idea what was said, what she said, because there was no attorney present. If you had an attorney present, the attorney would be, if there's a Stokes interview, which is when they separate the couple, the attorney has to be there at the interview of each of the parties. But there was no attorney, so now he doesn't know what the spouse said. He doesn't know because whether she was trying to sabotage him because she hated his guts. And so after the interview, no response from USCIS. So now he's worried, doesn't know what to do. So if he had come to an attorney would have basically would have figured out whether he qualified for an abuse waiver. And if he didn't, would have probably advised him, you need to file a divorce as soon as this relationship is, is not viable. File a divorce so that at least you can have the divorce waiver to use to self-petition to get your green card. So now a case that would have been a really simple case because it definitely was a bona fide marriage. They have a lot of stuff together, but who knows what she said at the Stokes interview, because USCIS has a habit of believing everything that the US citizen says just in order to deny the case. So that's one mistake that I want to warn you guys against, right? It is important that when you have a green card, you don't take that for granted. It's a green card. You're not a US citizen. That green card can be taken away from you. Now, when you become a US citizen, your immigration journey is over. Do people get denaturalized? Yes, but very rarely. But do people get their green card revoked? Yes, quite frequently. That happens. So it's important that when you get your green card, even if it's a 10-year green card, remember, you're still going to look to get naturalized. And USCIS now has another opportunity to review that green card application to determine whether they should allow you to keep your green card and get naturalized, or they should put you in removal proceedings and begin the process of terminating your green card. And remember, with this Trump administration, they're saying that if your case is denied, they will put you in removal proceedings. They will serve you with a notice to appear. So we also have people who are green card holders looking to become US citizens. They think, oh, the N-400, it's a really easy form. I can do it myself. And then they get before the interviewer and then their issues. It could be that they're not paying their taxes, they're not paying child support, maybe they were involved in some kind of, misdemeanor, crime involving moral turpitude or something, right? And an attorney would have told them, listen, there's a look back period, and it's better for you to file your N-400 after the look back period is passed, right? Typically, it's 5 years. And for some kinds of criminal offenses or some kind of misdemeanors or some kind of wrongful behavior, you may never be able to become a US citizen, and you may just have to have your green card forever. For instance, one good example is when you're filing for your green card and you omit the names of all your children in your petition. I don't know why people do this, but it's bad advice. Somebody tells them, if you put all your kids' names, you're going to be denied. I've never understood that. I really want somebody to explain why you wouldn't want to put why you wouldn't want to be honest and truthful, right? So they put some of their kids, they don't put all their kids, and then it's time to naturalize, and they're looking to become a US citizen and file for their children. And at that point, they want to put all their kids, all the names. And sometimes they go ahead and do that. They get to the interview and they get into trouble. Not only do they not become citizens, but they're now at risk of losing their green card status, right? So I want to urge you guys that at a time like this, the one thing I can tell you is that this administration is really, they're playing to the fears and anxieties of immigrants. They're doing that, no question about that. But if they find that you've done something wrong, they're not exercising any kind of any kind of kind, what's the word I'm looking for now? Any kind of kindness, or any they're not giving you any deference, or just, they're really going for the jugular. They're looking to limit legal immigration. They're looking to take green card holders and return them to non-citizen status. They're looking to deny green card petitions. They're looking to deny citizenship petitions. But the good thing is this: we immigration attorneys are still in the business of winning. We're in the business of winning green cards. We're in the business of making sure you get your citizenship. We're in the business of making sure that your papers are properly filed, so that you don't have to deal with issues that arise later. So I think, rather than worry about what's going to happen, what this administration is doing, worry about making sure that you're filing your papers properly. Okay, so I'm going to talk about other things, the common mistakes that people make that can also delay their cases, or get their cases denied because it's incorrect. One of them are easy filing mistakes. You're using the wrong version of the form. I'm going to tell you this. USCIS is changing these forms so frequently because they're putting new stuff, like in the N400. They removed the gender, because with the prior administration we had, the male, female, and I think the other section for another gender, right? With this, they're going back to male, female. So they're making a lot of changes in the forms. They're making a lot of changes in the green card, the I-485 forms. And so if you use the wrong version, they're going to reject it. And if your application was one that needed to be timely, then you might have missed your opportunity to file that paperwork. Now, incorrect fees are something you have to also be aware of, because incorrect fees are a reason why people get denied. You have to make sure it's addressed properly. U.S. Department of Homeland Security spelled out. You want to make sure it's the right fee, writing the right amount, signed properly. If you make a mistake with even the date, put in the wrong date, maybe you put 2024 or 2026 until 2025, they'll deny it and they'll send everything back. Missing signatures, make sure that you're signing the right form for you. If you're doing a marriage-based case, you should be filing, the petitioner, who is the U.S. citizen or the green card holder filing for their spouse or child, should be filing the I-130. If it's an adjustment of status case, I-130 is what the citizen should be filing, I-130 and the I-864, right? Now, the beneficiary should be filing the I-130A if it's a marriage case, the I-485, the I-765, the I-131. You want to make sure the right person is signing the right form. And if your children are under the age of 14, you can sign for them. Now, you want to make sure that you have evidence and evidence and documentation. So if it's a marriage case, or you're filing for a family member, you want to make sure that you're submitting the required evidence, such as the birth certificate, marriage certificate, passport copies. If it requires you to prove that you came into the United States, you want to have proof that you were inspected and admitted in the United States. If it doesn't require that, then that's different. But somewhere in the forms is going to ask you to indicate how you came into the United States. You want to make sure that you answer that. Now, if you're filing something like a VAWA or T visa or U visa, asylum, SJIS, it doesn't matter if you came in through the border. It doesn't matter if you came in without inspection or without admission. Now, another thing you need to make sure you have is translated copies of foreign documents. So if you are born in a country that uses a different language and your legal documents are in that language, you want to make sure it's translated. You want to make sure that your forms are consistent. The information that you give is consistent. So let's see. Another thing we want to talk about is timelines and deadlines. Missing deadlines such as responding to an RFE or appealing a denial or filing before a status expires, timing is critical. Now, another problem for those who are looking to get work permits is make sure that you renew your work permit timely, because there's a law that allows you to, as long as you file the renewal of your work permit, you get an additional 540 days. Okay, so if you miss that, then you're joining the long line of people waiting for work permit, which can really take months. So you also want to make sure that you're eligible for what you file for. For instance, if you're filing for asylum, you really want to file within the 1-year deadline, okay? Because if you file outside the 1-year deadline, you have to have really great reason, extraordinary reason for not having filed within that 1-year deadline. Now, let's talk about, let's see, those with complicated immigration histories. If you don't disclose your immigration history to a lawyer, you want to tell your lawyer what's happened in the past, because that information is there. USCIS will find it out also. So if you omit it or you don't, answer truthfully to those questions, then that's a problem. We in our office, we typically do not file cases without a FOIA for those who have an immigration history, because we really want to understand what happened before. And unfortunately, most clients don't really understand the legal dynamics of what their situations are. So it's important for us as lawyers to understand what's going on, so that we can be strategic with regards to how your case is filed. Okay. Now, so let's talk about bonus tips that you really should always be aware of. You want to keep a complete copy of what you file, whoever files it for you, your cousin, the notario, the prior lawyer, or you file it yourself. You want to have a copy of everything that you've submitted to USCIS. You want to consult an attorney if your case has any complications, because if you don't, you're setting yourself up. And really, I would say with this administration, they're looking to complicate your case. So it's really better for you to at least have a consultation with an attorney, so that you can determine whether it's a case you would be comfortable handling on your own, right? And another important thing, if you move, if you're no longer living where you used to live before, and you have filed an immigration application in the past, you really want to fill out the AR-11 and give USCIS your new address. It's the law, actually. You're supposed to do that within 10 days of moving to the new address, because if there is something important happening, so for instance, your case was denied, you have, and you're put in removal proceedings, if you don't show up, you cannot give the fact that you never received the mail as an excuse. And the reason is because you're supposed to update USCIS and let them know where your new address is. And if you don't, and they mail it to the wrong address, it's not an excuse. And typically, government mail does not get forwarded. Let me repeat this again. Government mail does not get forwarded. So if you move, you should change your address, okay? Let USCIS know what your updated address is, so that any mail that comes to you, you get it and you can react accordingly. So having said all that, if you or anybody you know needs immigration assistance, please give us a call, 973-993-1900. And remember, if you reach out to us on social media, make sure it's our social media account, because there are a lot of people masquerading as us and trying to scam people. So I'm going to answer some questions. So put your questions in the chat. Let me answer some of your questions. So Zach Gando says, 5 months after N400, no decision made. When Congressman contacted USCIS, they said they still need 90 days. Is there any chance of approval? Well, Zach Gando, I need to know what your case is about, to be quite frank. The truth of the matter is that there's a law that says that USCIS has to respond to give you a response after your interview within 120 days. So they're supposed to do that, whether it's to approve it or to deny it. They're supposed to do that. So if they haven't done that, you have a right to file a lawsuit. But when you ask me, is there a chance of approval? I think you would want to really talk to a lawyer to figure out what's going on. Are you one of those people that should not have filed for an N400? Regardless, it shouldn't take them this long to respond to you. I'm going to tell you that. So you still want to talk to an attorney to see if there's a way you can get that information faster. So if they're going to deny it, you want to be able to know as soon as possible so you can either file your appeal or, at least figure out whether you can fix whatever the issue is. So I can't answer that question with regards to whether there's any chance of approval because I don't know what your case is about, but I want you to know that they should have responded to you within 120 days. All right. All right. So let's go to Instagram. So finally, I get to see questions on Instagram in bolder fonts. So Fame Energy says, hello, I received a message from SJIS saying we have taken an action on your case, but the status is still the same. When you check online, I received the message 4 times repeatedly. Please, what do I do? Famine Energy, I don't know what your case is about, but I think the thing to do is do an e-inquiry, right? Because sometimes the status online is not as reliable. Sometimes, it's not as reliable as it should be. But I would say that most of the time when they say they've taken an action, they have. But I think it might be a good idea to do an e-inquiry. You can do that through your account, or you can give them a call. Or if you want our assistance in getting a FOIA, getting all your records and reviewing it and seeing what's going on, then we can assist you. But I think for starters, do an e-inquiry or call them and figure out what's going on, okay? Let's see. So God's Favorite 82 says, do we still update address even after you have gotten your green card? That's a really great question. Actually, you do, God's Favorite, because your immigration journey is not over just because you're a green card holder. So you do have to keep USCIS updated on your new address, even if you're a green card holder. Chidi also says, can my US citizen dad file for me to come via visitor's visa, even though we're still in the wait process of immigrant visa? So Chidi, that's actually a good question. And I'm going to tell you that the chances of getting that B1, B2 is not really high. And I'll tell you why. The reason is because when your father filed an immigrant petition for you, you have declared immigrant intent. So it's going to be hard it's going to be difficult to get a B1, B2 in that situation. Does it happen? It's not impossible, but I really don't, especially if you've never come to the United States before, I don't believe that you will be successful getting a visitor's visa because you have immigrant intent, Thank you, Lion Bodie. I appreciate that. All right. So Halima says, can one apply for student visa with a pending green card petition? So Halima, it would depend. If you are in legal status, right, which means that you have never had any period of unauthorized presence, any period of unauthorized employment, you have legal status, you can apply for a student visa. Now, do people typically apply for student visa with pending green card applications? Sometimes no, but there's no law against it. So you might want to have a student visa just to make sure that you never fall out of status. Maybe you've been in status now, and you know that if your green card petition is denied and you're out of status, you can't get back into school. So that would be a good reason to apply for a student visa and stay in status if you're in the United States. Now, if you're abroad and you have a pending green card petition, they're not likely to give you a student visa. Same thing with the B1, B2, because now you have immigrant intent. A student visa is not a dual intent visa. Okay. All right. So Zach Gander says, how to have an appointment with me. Please call my office 973-993-1900, or you can send an email to support@odunlamilaw.com. All right. You can go on my website and actually self-schedule, but it sometimes the times are longer and it's easier to call to get something. Or you can go online, make your appointment, and then call later on to see if you can move it closer. That's something else you can do. So let me go to TikTok because I haven't answered any questions from TikTok. All right. All right. Jack says PD and motion to reopen and dismiss, removing proceedings will take already 9 months. VAWA approved. All right. So your VAWA has been approved. Congratulations on that. So it seems you're in immigration proceedings, and you filed a PD and a motion to reopen and dismiss. So Jack, I hate to tell you this, but PD is in this administration is really non-existent. No one is responding anymore to PD, but you can file an application with the court, which will, the judge will make a decision on that, and that will be a way to reopen and dismiss your case. Okay, and congratulations on getting your VAWA approved. All right. I'm still on TikTok. All right, let's see. I'm looking for more questions. So I'm not seeing any more questions on TikTok, so I'm going to scoot over. Little Baddie says, if you submitted for all forms, all for marriage based, does this mean EAD card should be combo? Now, typically, when we want to get a combo EAD card, we in the I-765 we put CO9P for adjustment of status for the adjustment of status cases. USCIS used to just give a combo card, so sometimes they might still give it. We typically put the CO9P to indicate we want a combo card, okay? And advanced parole is taking a while, little baddie. It could take anywhere from 7 months and above. But if there's an urgency that requires you to travel, you can get an InfoPass appointment and take your receipt there and make a request for an emergent advanced parole, okay? Expedited advanced parole. Kate Axel, yes. If you want to do your address update, even if you have a green card, you should still update your address with USCIS. That's correct. That's the law. Winnie says, can I travel with the I-551 stamp international? Well, the I-551 stamp is what allows you to travel. But Winnie, the bigger question is, should you be traveling? Check that out before you leave because, yeah, check that out before you leave. All right. All right, so let me go back to Instagram. And so Ajaga says, got an RFE for an EAD. What does that mean? I don't know what the RFE was, so I can't tell you what it means because the RFE will tell you what they're looking for. All right. So Prince of Allen says, if a wife and husband live in different states due to their job, can there be an issue with immigration filing? Prince of Allen, USCIS likes traditional marriages, but does that mean that your marriage is not bona fide? No, it doesn't. It just means that they will apply some scrutiny to it when you don't live together. And you're going to have to be able to come forward with really, copious proof of a bona fide marriage. And you will need to be able to explain why you don't live together. And it happens. Some people don't live together. My husband and I didn't live together after we got married for I think maybe a year or two. And we're married now 23 years. It was not a fake marriage. We have kids, but it wasn't easy for him to move over to New Jersey because he was working in an underserved area for his own green card. So that was that. So it happens. It's not, but I would say that if you don't live together, it's there will be additional scrutiny, and you want to be able to withstand that. Okay. So Mudia says, I have a case. Please, can I get a direct line to call? Definitely, Mudia. Call 973-993-1900. It's not a direct line to me, but it's a direct line to my firm, okay? And somebody will schedule you. CC Yankee says, did you say they're going to review green cards already issued? CC, that's what they said. That's what they said. They said they're going to go back and review the green cards of people that were already issued. They're going to do yada, 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 all this stuff. They want to do a lot. But like I said, USCIS always has an opportunity to review green cards that were already issued when either you file to remove the conditions, you file to naturalize, you file for your spouse. There are many ways that they go back and do checks on the green card they already issued. But I don't know how the Trump administration intends to implement this. Are they going to just go through all the green cards? They said they're looking to go through the green cards that were received, especially in the recent administration. I don't know how that's going to happen, because their hands seem to be pretty full with their mass deportation. So, but what I'm going to tell you is, one thing this administration is good at is making people anxious, spreading chaos, confusion, and I would say just don't get sucked into it, okay? If you have any concerns about your immigration paperwork, talk to a trusted attorney, and that's really it, okay? Let's see. Halima, yep, they would not pass. You said you filed for your son, and they refused because he's ineligible. You wanted a B1, B2 for him, but you already filed a petition for him, an immigrant petition. Yep, because of the immigrant intent. When you file an immigrant petition for somebody, they're establishing an immigrant intent. So typically, not always, because there's nothing in the rule books that say that they cannot come on a B1, B2, or an F1 or another non-immigrant visa, but the practices of the Department of State is not to give them a visa if they've never been here before and they haven't established a positive travel history to the United States, and they have a petition pending. All right. So Nikki says, can I marry my spouse on my visitor's visa, and do I have to wait 90 days before putting my paper in? So Nikki, that's a really good question. And if you come here on a visitor's visa is a single intent visa. You're supposed to come and go back. You're not supposed to have the intention before you come here of coming here and not going back and then getting married and filing to adjust your status. That's what the rules say. However, the rules also say that if you come here without any intention of staying, but after you come here, you change your mind and you decide to stay, you can go ahead and marry your spouse and put your papers in. So the question boils down on your intent. And if USCIS thinks that you had you had that intention, it's up to you to prove that you didn't intend to stay, and something happened and you change your mind, or you just change your mind. That happens, Mudia says, I have an O2 visa. My wife and daughter have O3. How can we change our status to apply for residency? So Mudia, you have to have a pathway, to be able to, is somebody filing an employment visa for you? Do you have somebody, any other pathway? To get a green card, you have to have a pathway to it. All right. Thank you, Onwa Munri. I appreciate that. PD Halima is prosecutorial discretion, which means that the ICE attorney really, you've convinced them that it's in their best interest not to try to deport this person, typically because the person has no criminal record, the person is a good moral citizen, the person has a pathway, and it's really better to just terminate the immigration deportation proceedings and allow them to go and adjust their status. Okay, that's what PD is. Let's see, I'm back on Instagram. So let's see. I want to get a question. So Piccola says, I got my green card in 2023, and I have a DUI you had a DUI from 2004, 21 years ago. You know, a DUI is not really an issue as long as there are no aggravated circumstances, like you got your DUI, multiple times. You got your DUI in a child is a school zone. It's not really a problem to becoming a U.S. citizen. So, but I will recommend that you talk to an attorney so that we can properly screen this case. But the good news is many people have DUIs and have become citizens. Okay, so if that was your one and only 21 years ago, I think you would be okay. But best practices is always to talk to an attorney. All right. So Mosadik says, what if I withdraw my case even if my interview is scheduled? So Mosadik, even if you withdraw your case, USCIS still reserves the right to, deny your case, which they will, and they still reserve the right to put you in removal proceedings if they wish to. So just withdrawing your case does not mean that you're free of consequences, okay? All right, let's look. Hello, Naxi. So patient says, is it possible for an F1 student in community college who has over 10 years working experience back home apply for EB2 national interest waiver? Patients, EB2 national interest waiver requires either a master's degree or a certain amount of years with a bachelor's. So I don't know whether community college is the highest educational level, but you might be best served with talking to an immigration lawyer to take a look at that for you. All right, let's keep going. So Terry says, can I remain in the country while I apply for a change of status from H1 to F1? As long as you have no unlawful presence, you should be able to do so. But Terry, always contact an attorney so that you can discuss the fine details of your case, okay? So Noel says, I got married since January and my wife graduated as LVN and started to work today. Can she file for me though she just started work, or do we need an affidavit of support since she just started work today? So Noel, there are many questions I would ask. What is your status? What is your wife's status? Just because she started work does not entitle her to file for you. So the question you asked really doesn't have a lot of information. So CJ Heston says, I recently got married to a US citizen. Well, congratulations. Can my wife apply for her now stepson who's under 21 and is in college on a student visa? So CJ, your wife can apply for her stepson, which is your son, only if he was under the age of 18 when you guys got married. So if he's under 21, but he's over 18, he's not a stepchild for immigration purposes. So she's not going to be able to apply for him as a step parent, okay? All right. So official says, I have a friend who is above 22 years. She did her studies outside the US, but her parents are US citizens. Please, I want to know if her parents can file for her to come over. Definitely they can file for her, official. It's just going to take a while. And it's going to take longer if she's married. But yes, her parents can file for her. All right. let's see. So Chemaka says, I was denied an F1 in 2023 and a B1 visa last year. When do you advise I apply again? This time an F1. I plan on having my master's in the United States soon. No immigration intention. Thank you. So Chemaka, I'm going to tell you that getting a B1 and F1, typically you don't have to have an immigrant intent for them to infer immigrant intent. So it is hard to get those visas approved because you have to show you have ties to your country. And sometimes even when you have those ties, they can still say no because F1, B1, they're privileges, not rights. Those visas are privileges, not rights. So, I don't have an answer for you on that, okay? All right, I'm trying to look for questions. Now I'm going on TikTok. So Michael is asking, my wife is a physician on H-1B and I'm on H-4. How long would it take for my wife to get a green card? So Michael, is anybody filing for a green card for her? Because a H-1B is not an immigrant visa, you know that. So hopefully she's filing under EB2, maybe under any of the EB categories, okay? And so H-1B is a non-immigrant visa. She still needs somebody to file an immigrant petition for her. So Kensman says, is it true that USCIS must schedule an interview since its administration? Well, Kensman, it is true that they intend to schedule interviews for marriage cases. That's what they said. We all know that during the Biden administration, they were waiving a lot of marriage cases. This administration has indicated that they have no intentions of doing the same. So yes, expect interviews. So Orlando says, I have a question. Do Social Security and credit card company have interaction if I wanted to get a credit card? All right, so that's not an immigration question. So I can't tell you whether your credit card company is talking to your Social Security. But I don't know I don't know. That's not an immigration question, so I'm not going to try to answer that. So Junior Dave says, can I apply for citizenship immediately after joining and signing my contract in the National Guard? I think you have to have had your green card for 1 year, if I'm not mistaken, before you can apply for citizenship. So yeah, I think you have to have had your green card for 1 year. All right. All right. So let's see. So yeah, Halima says, is someone with an EAD and pending I-130 called a non-immigrant? Yeah, you're not an immigrant. Well, I don't know. You're not an immigrant in the terms of having legal status. So I actually haven't heard people being called non-immigrant. So yeah, I don't know what that question's for. I'm trying to make sure I'm getting all. So Piccolo says, is it okay for me to travel with the 21 years again DUI? Piccolo, you really want to talk to an attorney because I'm not here to give legal advice. If you called my office, I would scrutinize your case and advise with regards to whether or not to travel. So you really shouldn't take advice from attorneys who are just doing a social media live for informational purposes, because this is pretty serious. You need proper information, okay? And if I were to just talk about this kind of cases, I tell people right now, you really just, unless you're a U.S. citizen or unless you're a U.S. citizen, you probably don't want to be traveling at this time, or a green card holder that has no arrest history, no issues with, law enforcement. Okay. All right. So John says, you're a permanent resident charged with DV, domestic violence. You pled guilty to littering. Are you in risk of deportation? So, John, domestic violence is a deportable offense. So before I would answer that question, I would want to see the court records, because just because you pled guilty to littering does not mean that you didn't plead guilty to something else that might be a problem. I don't know enough. I don't have enough information, so I won't. I can only tell you that DV is a deportable offense. I'm glad you pled guilty to littering, but I can't offer substantive advice on important information such as that because I don't have enough information. All right. All right. Okay, guys. I think that's pretty much it. So I was here for almost an hour, and you know why? I was here for almost an hour because I have a new iPad that allows me to read your questions. In the past, I struggled with my iPhone that was so tiny. So yeah, I'm really happy that I could assist you guys. So Adora KK, one more question. He says, if you're denied your I-290B, can you refile again? Not the I-290B, but you can refile maybe the marriage-based case, maybe the VAWA, whatever it is. You may be able to, you can refile those if you're not out of time for, say, the VAWA. So Adora, you may want to talk to an attorney, okay? All right, guys, it was a pleasure chatting with you guys. Again, if you need our assistance, please feel free to call us at 973-993-1900, and or you can send us an email at support@odunlamilaw.com, or go to our website, www.odunlamilaw.com, and schedule a time to speak with one of our attorneys. All right, have a good evening and wish you all the best. Take care.